Court of Chancery of the State of Delaware, Delch Transcripts, Exhibit 1. The Court.
Welcome, everyone. Thank you for being here. I'm happy to start with introductions. It probably would make sense to do so from the defense side, but given how long we've been together, I'm also happy just to get straight to it. Mr. Lafferty, why don't you go ahead?
Attorney Lafferty.
Good morning, Your Honor. I'm here on behalf of Mr. Skaggs and Mr. Smith, and with me at counsel table are Mr. Savitt and Mr. Yavitz from Wachtell Lipton, my partner Ryan Stopman as well. In the back we have my partner Lauren Neal and a summer associate, Apoorva Gokare, who I believe saw you speak at the University of Iowa. This is her first time in a courthouse today.
The Court.
Oh, great. Well, thank you all for being here, and particularly Ms. Gokare.
Attorney Lesner.
Good morning, Your Honor. Marty Lesner from Young Conaway on behalf of TransCanada.
With me at counsel table is Brian Massengill from Mayor Brown, my partner James Yoke, and Kevin Rickert.
The Court.
Great. Thank you all for being here as well.
Attorney Weinberger.
Good morning, Your Honor. Ned Weinberger from Labaton Sutro on behalf of...
Attorney Jenkins.
Good morning, Your Honor.
Attorney Weinberger.
Just briefly, Your Honor. I discussed with Mr.
The Court.
I want to say thank you to you all for being here as well. I appreciate it. Please go ahead.
Attorney Weinberger.
I discussed order of presentation with Mr. Lesner. What we discussed was that, with the court's permission, Mr. Van Quawigan would present the settlement. I would then follow him, present the motion for class certification, and Mr. Lesner would then respond to both of those motions. Of course, if the court has a different preference, happy to go in a different order.
The Court.
Yes, I want to go in a different order. I want to do the motion for class certification first.
Attorney Weinberger.
Certainly, Your Honor. Again, for the record, Ned Weinberger from Labaton Sutro on behalf of plaintiffs. I'll try to be relatively brief on this motion. I'll start with our affirmative motion, then turn to TransCanada's opposition. I know the court is very familiar with the standards on a motion for class certification. The case needs to have met the 4 Rule 23a factors: numerosity, commonality, typicality, and adequacy. The case also needs to satisfy at least one Rule 23b condition. And just very briefly, let me tick through the Rule 23a factors. Numerosity, hundreds of millions of shares in the proposed class. That element should be easily satisfied. In terms of commonality, every member of class was owed the same duty of loyalty and care. Every member of the class received the same 25.50 per share in the merger consideration. In terms of typicality, we are not asserting any. Plaintiffs are not asserting any claims that are unique to them, nor are plaintiffs subject to any unique defenses. Plaintiffs are passive institutions that have held stock at close and are actively seeking to recover for themselves and other former public stockholders of Columbia. In terms of adequacy, plaintiffs retained competent counsel. I don't think that's in dispute. Plaintiffs have no conflicts, and we would submit, as we do in our papers, that the partial settlement that Mr. Van Quawigan will present is really objective evidence that Mississippi and Detroit are advancing in protecting the interests of Columbia's former stockholders.
The Court.
That's all correct. And what you're saying is consistent with how we've been doing these things for decades. But the defendants have chosen to advance some novel arguments. They've drawn on a lot of different sort of a hodgepodge of case law, a grab bag. If you could find a class certification decision from any context whatsoever, they've cited it. And they've done so to advance to really one major theory, which is this cross-ownership concept. Why don't you engage with that? Because, as you suggested, what you've just said is pretty much straight down the middle in terms of how we've been doing these things for decades.
Attorney Weinberger.
Sure, Your Honor. I think that's an accurate characterization of their opposition. It is a bit of a grab bag. I'm going to address these points. I think what I would first say, a small point, but I think an important one, sort of what I've just laid out on 23a. I didn't get into 23b, but with what's laid out in our papers, we would submit we easily have made a prima facie case under 23a and 23b, such that we've met our burden. As a result, the burden then shifts to my friends to establish, to come forward with some legal argument, something so unusual about the facts of this case that it would compel the court to take the unusual step of denying certification. And on this first argument, the cross-holdings argument, it's answered by Erden. It is answered by the Delaware Supreme Court's decision in Erden v. WR Capital Partners, which is a decision that's not even cited in their opposition to the motion for class certification. And the reason it's not cited, as we point out in our brief, they effectively, I don't know a better way of putting it, copied it, cribbed, lifted, a scorched earth grab bag opposition that Mr. Van Quawagen and I faced in straight path, doesn't address the controlling binding Delaware Supreme Court precedent confirming that these are claims that inhere with the shares, such that the characteristics of who in fact held those shares is largely irrelevant, absent some unusual or unique circumstances that just simply are not present here. And, Your Honor will note, we cite the orders, we cite the precedent in our brief. My friends have not been able to point to a single decision of this court, transcript, order, opinion, where the court so much as contemplated excluding crossholders from the class. And there are many reasons. The most fundamental reason is, as Erdan explains, this concept of claims traveling with the shares, inhering in the shares. Had my friends read our reply in straight path, they would have seen we laid out these arguments very plainly, cited the relevant authorities. If my friends had looked at the transcript from the class certification hearing in straight path, they would have seen Vice Chancellor Glasscock giving the absolute shortest of shrift, to the cross-holdings argument that Mr. Lesnar is advancing here. They advanced in straight path the same ascertainability argument that my friends are advancing here. We actually have to go into the class, remove all the stockholders who in fact, held shares of TransCanada stock. Vice Chancellor Glasscock responded to that argument at the hearing on the class certification in straight path. So it doesn't make any difference. Quote, from page 133 of his transcript, it doesn't make any difference, because the claim adheres to the stock, and the fact there was other stock owned by someone that may have benefited from the faithless act but who didn't participate in it, it's immaterial. There's no allegation of TransCanada, or not TransCanada, of Detroit or of Mississippi having participated in any of the wrongdoing. My friends advanced this argument on the objection to the settlement, that Detroit should be excluded and holders of TransCanada stock should be excluded for the same reason that we've stipulated to excluding defendants Skaggs and Smith from the settlement. They're obviously being excluded for very different reasons. They acted disloyally. They were active participants in the wrongdoing. That's not the case with Detroit and Mississippi. And the other showcase argument about excluding the members of the appraisal class, that's answered by Erdan as well. The class claims the equitable claims inhere in the shares that were held by each of the appraisal petitioners at the close of the merger. Those claims haven't been adjudicated, as Your Honor noted, or has noted multiple times previously in this case, nor did any of the appraisal petitioners release any equitable claims during the pendency of the appraisal litigation or at any other time. In fact, if Your Honor recalls, back in 2018, TransCanada had the option of stipulating to consolidation of the two cases having these issues decided at one trial. They opposed it. They said the fiduciary duty claims can wait. They said that they wanted a trial on solely the statutory claim, and that's what they got. So this is really a situation of TransCanada's own making.
The court.
Let me push you on one thing on the appraisal action aspect. As to the appraisal claimants, they were parties to a case where factual findings were made. So it is true that I held in the dismissal ruling that the legal issues were different, and therefore it didn't necessarily follow that a ruling in the appraisal case translated into an outcome for this case. And obviously they're attempting to relitigate that with the formula argument that they make. But setting that aside, why isn't there a valid point that as to a factual finding that someone actually litigated and obtained in the appraisal case, that factual finding would be binding on that appraisal litigant?
Attorney Weinberger.
Well, Your Honor, and I'm going to directly address this question. The first response is, the court didn't make findings under what will be the essential questions at the trial scheduled to commence next month. So under enhanced scrutiny, whether fiduciary duties were in fact breached, whether there are damages, Your Honor has posited a scenario where, I believe the scenario Your Honor is positing is there is some finding in
the court.
Let's make it simple to the point of trivial. Let's assume that there was a question as to whether an event happened on the 1st of June versus the 10th of June, and that might have different implications legally, depending on what the issues are. But it's a fact question as to whether the event happened on June 1 or June 10th. In the appraisal case, there's actually a finding made that it happened on June 1. Why isn't that factual finding binding as a matter of collateral estoppel, even if it wouldn't be binding as to the legal implications?
Attorney Weinberger.
Well, Your Honor, I think we would concede that that binding, or that finding, that factual finding, may very well apply to the appraisal petitioners who are part of the class.
The court.
Yes, that would make sense to me too. And so, as I spin this out sitting here today, we don't know whether it's an issue or not because we could get to trial in the follow-on case and I could hold that it actually did happen on June 1, and it wouldn't be a problem. or because discovery has unfolded differently in this case and there's different evidence, I could hold, wow, I now can see that this actually occurred on June 10, and things were backdated, to make it look like June 1, and you pulled one over on me on the last one. But so be it, or I was mistaken, whatever the answer is. And then the question would be, does that have any legal implication, right? But, I mean, you could, in theory, it seems to me, at the end of this rainbow, get to a situation where you had a subset of folks consisting of the people who actually litigated the appraisal case who would be bound by June 1 and whatever flows from that, and a different set of people that could seek and obtain the finding that it was actually June 10. Does that make sense to you, or do you disagree with that? As I was trying to think through these things, it seemed to me like that was a potential possibility, but you've been spending a lot more time with this stuff than I have, so feel free to explain to me where I am going off the rails.
Attorney Weinberger.
Certainly, Your Honor. So what I would say is a few things. 1. Standing here right now, I cannot conceive of a factual determination the court would make at trial that would be undermined by any of the findings that the court made in the appraisal trial, to the extent those findings would be binding on the appraisal petitioner. But to more directly,
the court.
Let's set that aside because we're all human, and we have difficulty conceiving of things, particularly when they're things that we don't want to have happen.
Attorney Weinberger.
So, the second scenario where the court made a June 1 finding but based on, hypothetically, discovery misconduct, documents were not produced that should have been produced, evidence was not proffered that should have been proffered. I think that is the argument that those findings would be binding on the appraisal petitioners, I think is weaker. And we certainly have, various mechanisms that can be employed to deal with that, including potentially reopening the judgment in the prior decision based on findings the court makes.
The court.
That's all true and well and good, but I still want to push the absolutely clean focused question of the collateral estoppel effect of someone who actually litigated to judgment in the appraisal case versus other class members who did not. Again, let's make it even cleaner, and we can insert sort of the black box of the jury in terms of fact-finding or something like that. But imagine that you're simply in a case that was litigated by certain members of the class but not others, reached a finding that it was June 1, absent Rule 60 or some way to set aside the validity of that first judgment. Are those folks who actually litigated bound by the June 1 finding, or is there some reason why you think they wouldn't be bound by the June 1 finding?
Attorney Weinberger.
I think it's quite possible they would be bound by the June 1 finding, and to hypothesize some scenario where the court made some finding inconsistent with the finding in the appraisal action that it turned out was essential to some type of recovery or judgment, would obviously be the most extreme scenario. To me, that is something that the court can deal with post-trial. But it's certainly not an issue we would submit that needs to be addressed now, before trial, before the court has made additional findings. But the scenario you hypothesize, Your Honor, it's certainly possible, yes.
The court.
So then, again, if we're in the world of possibility, it sounds to me like you're suggesting that this is a problem that we deal with down the road if it happens, if in fact there is a different factual finding, and if in fact there's a conclusion that the different factual finding has some legal significance such that the appraisal petitioners would face a different outcome because of the earlier factual finding.
Attorney Weinberger.
Yes, Your Honor, and I think we addressed this in a footnote. I think the court has a number of mechanisms, including, I think Rule 23 even expressly says that the court can at any time, including post-trial, modify an order certifying the class.
The court.
So your view is that we would deal with that down the road. All right, now, let me ask you a couple other things that I think are curiosities. To the length of the class definition, and I want to distinguish between the length of the class definition for the litigation and the potential length for the class definition for the settlement. I mean, this is a dialogue that I've had with folks over the years about why the class definition starts typically at the beginning of the time period for exploring strategic alternatives and ends on the closing date. I mean, that's like the standard definition.
Attorney Weinberger.
Right.
The court.
People use. So from time to time, I'll ask people in settlement hearing colloquies, because that's usually when it comes up, why are we doing this? The claims travel with the shares. It's going to be the people who end up with the claims as of the closing date anyway. Why are we doing this? And the answer is always what you all alluded to, and what Mr. Lafferty more thoroughly presented, which is, look, we're getting a release. The release is covering a lot of different claims. There's potential federal claims out there. There's maybe common law fraud claims. We don't think they're worth anything, but we're bargaining for this release. So we want the broad temporal period to sweep this in. And so that's why we agree to the broad class definition. Your Honor can weigh whether or not those claims are worth anything. Nobody's coming in and saying they are. On we go, and, historically, on we've gone. And that completely makes sense to me in the settlement context, right? I buy that. Now let's pivot to the class that I'm being asked to certify for you, for litigation purposes, and let us distinguish between what you would think a defendant wants and what sort of legal theory would say. Alright, so what you think a defendant would want would be the same broad class definition, because they want res judicata effect one way or the other as to the full scope of the class, right? So if they win, they want everybody bound, and even if they lose, yes, that's a bad day at the office, but you still want everybody bound so you don't have to do this thing all over again. So, again, we can see what TransCanada's doing in terms of acting counterintuitively by coming in and saying, no, we want the narrowest possible class definition. We do not want the broad thing that would protect us with res judicata. We want actually a narrow one. Let's set that aside. Let's just think about, in the abstract, what the Delaware definition should be. And in a world where all of the Delaware claims that you're litigating travel with the shares, why isn't the answer just the universe of holders at the time of closing? Because everyone up to that point who was a holder during the class period sold. Claims traveled with the shares. And so, really, in terms of what I would be doing in any type of liability ruling, right? Your best day at trial, any type of liability ruling, I'm going to be making a determination that's going to go out to whoever it was that held those shares at the effective time. So for the litigation definition, as opposed to the settlement definition, and setting aside that, I think, other than somebody trying to throw sand in the gears, which is what we've got, no defendant would ever argue this because they benefit from the broader definition. So this is like one of these issues that really shouldn't be coming up as a practical matter if people are actually not just being obstreperous. But why? From like a purist standpoint, isn't the answer that it ought to be shares as held at closing?
Attorney Weinberger.
So, Your Honor, I will make a concession. Somewhat of a concession. The answer to your question is, I think, usually, ordinarily, the litigation class period for a Delaware claim challenging a merger, it makes sense. It's close. Claims travel with the shares. Anybody who sold before they've disassociated themselves with the shares such that they've relinquished the claim. Ordinarily, that probably should be the definition. I think if you look at the majority of the stipulated class certification orders outside of settlement context we've entered into over the last 4 or 5 years, my firm and Mr. Van Quawigan, Mr. Varallo's firms, it is generally just a one-day class period, close. I think here, so Your Honor was not asking about precedent, Your Honor was just wanted to discuss what should the rule be, so I will leave aside the precedent, that, class definition looks a lot like, even the class that was permanently certified in rural metro, in Dole, Haverhill v. Curley, which Your Honor approved.
The court.
It's because no one's fighting these things, right? The broad class definition is something where, for a corporate case, people's interests are aligned in terms of the class framing. I mean, you'll have to refresh my recollection. I just don't know. Were any of those contested definitions where somebody came in and made the argument? I mean, the only person who actually would have a rational interest in contesting the size of the class would be a competing plaintiff who, for example, was asserting federal securities claims and didn't want to get carved out. It's just counterintuitive for the parties actually before the court in the case to do this. So were any of those contested?
Attorney Weinberger.
I don't believe any of those were contested, Your Honor. I mean, I do place significance on the fact that I think the court has an independent obligation in connection with
the court.
Look, I think about this stuff and I try to, it's a fair point you make. I interrupted you because my sense was that those were going to be not contested. You were winding up to say what you thought the approach really ought to be.
Attorney Weinberger.
I've conceded somewhat, Your Honor, that I do think ordinarily the one-day class period does make sense for Delaware law claims. When I look at this case, and in terms of even sort of leaving aside, how do you get comfortable by representing a class knowing that many members in that class likely sold their shares, gave up, essentially, their right to recover on a Delaware law claim? I consider that this is a 6-year-old transaction. The tires on this transaction have been kicked by plaintiffs and plaintiffs' counsel about as hard as one could possibly kick the tires.
The court.
You guys are inside the engine. You guys didn't just kick the tires. You took it to the mechanic and had the mechanic go over it. And we're still in that process, right? We're still in the process of we're all under the hood at this point. But anyway, your point is a valid one.
Attorney Weinberger.
And we appreciate that, Your Honor. Yes, So I sort of look at the history of this transaction. What is the extent of the litigation? 6 years of litigation, appraisal claims litigated through trial, full record there, developing different record here. And we also know that folks have tried to assert federal.
The court.
I mean, what flows from that is, therefore, those claims for other people in the class period aren't really worth that much. Isn't that the answer?
Attorney Weinberger.
Yes.
The court.
Sort of the next step. Again, that strikes me as an eminently fair point on the settlement. Eminently fair. But for purposes of the class that you get to represent going to a judgment, why does that matter? In other words, yes, somebody might have a Delaware law common law fraud claim. Or who knows what might have survived under the federal securities laws or something like that. Why did they get swept along with you when you are pushing Delaware law claims in terms of getting to a judgment, separate from what you could settle? I'm not questioning what you can settle. I'm questioning for purposes of the Delaware claims that we're going to litigate.
Attorney Weinberger.
And my response would be, again, and leaving aside the settlement, ordinarily, I don't think those folks should necessarily be swept along. Here, where we basically had, over half a decade to evaluate every conceivable claim that could be brought on behalf of former stockholders of Columbia Pipeline, who, certainly Mississippi and Detroit have a relationship to everyone in the class in that we all held stock at some point. Mississippi, Detroit, every member of the class all held stock at some point, had a duty, we allege, breach at some point this was a year-long sale process. So hopefully that answer is not unsatisfying to your honor, but again.
The court.
What implications does it have? I mean, really what I'm wondering is, look, why on this one doesn't TransCanada get what it wants? In other words, these guys have come in and said, no, we don't want the broad class that could protect us on res judicata grounds. We just don't want that. We actually just want a one-day class for litigation purposes as to going to judgment. And again, it doesn't have to be the same as the settlement class. You can settle a broader group of claims. So why don't, for the settlement, I give you the class that you all bargained for? But for the litigation class, why isn't the answer, you know what, TransCanada, you're right, this is a theoretically, doctrinally correct point that you are making. You should not get broader res judicata protection from this than you deserve. That is a fantastic point. We'll just make it class as of closing. Why isn't that the answer?
Attorney Weinberger.
I tend to agree with your honor. As we lay out in our papers, there is no requirement that the settlement class and the litigation class be identical or be the same thing. It doesn't create any issue that we can conceive of. It doesn't create any issue. So, yeah, to the extent the court were inclined to certify a settlement class consistent with the class negotiated for by defendants Skaggs and Smith, certify a different class for purposes of a judgment or later settlement in this case, I don't think Detroit or Mississippi would have any objection to that, Your Honor.
The court.
Yes, and to be fair, all I would be doing on the class certification motion is the class that you guys would be litigating, potentially to judgment if my hopes of broader settlement have dimmed, but it wouldn't impede people from getting a broader class along the lines of what Mr. Lafferty and his CO counsel negotiated in the context of a settlement. Again, doctrinally, this is one where the point lies oddly in TransCanada's mouth, but it's a point that seems well taken in terms of the doctrinal step. It's just something no defendant usually asks for.
Attorney Weinberger.
We would agree with Your Honor, and that's certainly within the court's discretion. And if that's how the court wants to deal with this class issue, like I said, Mississippi and Detroit have no objection to the court certifying two separate classes.
The court.
Anything else you want to tell me? I'll tell you the other thing that I was curious about. And it's not front and center in TransCanada's briefs, but they put it out there. And again, it's one of these things that would have colossally borderline nuclear consequences for how we've been doing things for decades. But their view is that once you're in the damages context for disclosure claims, reliance, in particular, becomes a sufficiently particularized issue that you can't certify under B1, B2, and indeed, under B3, you can't certify at all. And that would be big because that would mean that, really, you couldn't do disclosure class actions, period, or I guess you'd have. That's probably an overstatement. But the way we've been doing them for decades we would have suddenly discovered was wrong. But setting aside the innovative nature of the argument, what's the conceptual response? Because it is true under the federal securities laws, which is one of the sources for the potpourri of citations, although a lot of them are antitrust, a lot of them are consumer injury cases, it's all over the map. There is this concept that reliance can be individualized. What is your pushback to the re-envisioning of how disclosure class actions work?
Attorney Weinberger.
Well, Your Honor, I think the place I would start is the court's decision denying summary judgment in Orchard, where I think you talk about the availability of a post-close class disclosure claim and that the element of reliance, I believe Your Honor said, been a while since I've read that decision, we presume reliance based on a proxy's been issued, we presume reliance. And one of the reasons why the court might presume reliance for purposes of maintaining a class mechanism, I think the policy in Delaware is in favor of certifying classes allowing rationally apathetic stockholders who have been aggrieved by faithless fiduciaries, whether in the disclosure context or otherwise, to assert class claims. And as I understand the law, historically, I'm blanking on some of these case names right now. I believe there is case law saying that where stockholder action is not sought, maintaining a class action is going to be more difficult. Maybe it may just not be possible, given particular individualized issues of reliance, where you can't presume it. No stockholder action is actually being sought. But I think the law on this is fairly well settled, and I think in part it's sort of a function of the policy in Delaware, which is in favor, as opposed to allowing class claims to go forward.
The court.
Interesting. Look, I think the non-stockholder action context, the Malone claim, and Malone says it can be brought either on a class basis or a derivative basis. So what I'm hearing you say, it sounds like, is that we ought to have separate. The question is not just is disclosure being sought for injunctive relief or damages. The question is still, is it stockholder action or non-stockholder action? And within the context of stockholder action, we can presume reliance because the board is actually putting out this information to solicit stockholder action, and therefore, that, at a minimum, gets you enough to be able to certify a class, absent some evidence from the other side that would cause some different reliance calculus.
Attorney Weinberger.
Yes, Your Honor. And, consider the alternative. This is a class of hundreds of millions of shares within it, and this is a starkly misleading proxy. I know the court, that's our allegation. We intend to prove that at trial. I think it's already in part been proven, but not to the degree to which we'll be able to prove it at trial in July. But the alternative, if you make reliance an individualized issue such as you can't certify a class, you just lie to your stockholders.
The court.
It wouldn't be that far, but this certainly is sort of the person who their dream, right? Because you would be able to pursue these claims in the injunction phase where reliance doesn't come into play, but once you got post-close, this would be the silver bullet. You couldn't certify a disclosure-based post-close stockholder action because of the individualized element. So it wouldn't be that there would be no remedy. That I think would be an overstatement. It would be that it would be massively circumscribed compared to what has been the practice. I don't want to dismiss your point, which I think is, look, this would be a massive discovery to realize that we had been doing this wrong for so long, but it wouldn't let you just lie with impunity. It would simply narrow the window to injunctive relief.
Attorney Weinberger.
Certainly. A claim for damages would be largely unavailable. And I just note, Your Honor. Your Honor was noting how strange it is for TransCanada to be in this courtroom, asking for a shorter as opposed to a longer class period. I think the 23B3 argument is just as strange. I can't recall, other than in straight path, a defendant advocating for stockholder right of opt-out. Truly odd.
The court.
Yes. I'll push back on you a little bit only because I do think that the folks who mainly litigate in federal court and are immersed in the Walmart v. Dukes line of case law, for them, the idea that a damages class has to be A, B, 3 class, it's almost like an article of faith. And so it is not infrequent that I'll get arguments driven by folks from that world who want to port that framework into the Delaware law idea. That's why it keeps getting rejected. You guys cited all the cases. Chancellor Allen rejected it in 1991. It seems every 5 or 6 years, we have to come back and say this again. I can understand if what you are in the business of doing is fighting B3 classes, and you often can blow up classes by pointing at B3 factors. It's not crazy that you'd say, oh, well, I want to take this technology to Delaware, fight the B3. Battle in Delaware. Blow up whatever classes I can under B3. In Delaware, I don't want to face the B1, B2 class. B1, B2 class. That to me is somewhat rational in the long, but I do hear you in saying what is bizarre is a B3 class where suddenly people could opt out and these people would have to litigate claims both individually and class, like they do under the federal regime.
Attorney Weinberger.
Any other questions I can answer for Your Honor? If not, I'm Mr. Van Quawigan.
The court.
That would be helpful. Again, since I don't see full overlap between these things. And in fact, I wholeheartedly agree with you that I'm not really sure TransCanada even has standing to speak on the second issue. I was planning to hear this one, where I think TransCanada does have standing to oppose, and see what they have to say on this before we turn to the second point.
Attorney Weinberger.
Any other questions I can answer for Your Honor? If not, I'll let Mr. Lesnar come to the podium. Thank you, Your Honor.
Attorney Lesnar.
Thank you, Your Honor. Good morning. Your Honor, let's focus on the main issue here on why we believe that the proposed class is overbroad. We believe it's overbroad because it includes the dual stockholders who are not injured, and it includes the petitioners from the appraisal, who are precluded from bringing those claims. So I'll focus first on the dual stockholder issue. And the reason this comes up, of course, is because we're in a class action context. Detroit, it's undisputed. There's a couple of things that are undisputed, the federal law on the subject, and that Detroit owns a predominant amount of shares in TransCanada. So the issue is whether the court looks at this particular transaction, the merger transaction, and finds that people were injured or not injured at all differently, depending on their cross-holdings. That issue has never been litigated, as far as we know, in Delaware. And so the precise issue before the court in the class certification context is when looking at the hundreds of thousands of stockholders who own 400 million shares and certifying a class, does the court include in those class stockholders, like Detroit, who have not been injured? And we take that so it is an issue that has not been decided before in Delaware. I have not seen it in the context of federal cases either. So, as Your Honor rightly notes, we have analogous cases where the courts determined that there hasn't been injury to certain people in the class based on antitrust violations or others. So we start with the Supreme Court of Delaware in the Witt case, where the court says the parties also agree that failure to show that some fact of injury exists can defeat class certification while issues going only to measures of damages, while issues going only to H measures of damages cannot. So we don't contend that because stockholder A owns X amount of shares and stockholder B owns Y amount of shares, you wouldn't be able to calculate ultimately damages. What our argument is, in this particular transaction, which is a merger between two very large publicly traded companies, where there is some amount of cross-ownership, witness Detroit, which they claim they're typical of the stockholders, and they have a predominant amount. Were they or were they not injured in the transaction? So the court, having not dealt with it, but the court does look at the stock holdings of a stockholder in particular transactions. The undisputed holdings of Erdon simply says the cause of action goes to people who hold those shares, but the cause of action that they have is for breach of fiduciary duty, in that TransCanada did not pay as much as they said should have been paid in the transaction. So the breach of fiduciary duty is a duty that's owed not to pieces of paper. The breach of fiduciary duty is owed to the stockholders, and that is, Revlon, every other case, it's the duty to the stockholders as a corporation. This is not an in rem proceeding that says that you owe some sort of duty to the piece of paper. And, as a matter of fact, we cited a case where you cannot have an in rem fiduciary duty proceeding. So now the issue is this the type of transaction where the court will look at the transaction as a whole, sort of like knotting a step transaction, where the court looks at the transaction as a whole, a spin-off and then a merger, and looks ultimately to the transaction to see what stockholders have been damaged? And the concept that dual stockholders have not been damaged, I'm going to say it's not new, it's not novel. The court considers the dual stockholdings in other contexts of our corporate law, particularly in determining whether a stockholder is disinterested or not. So a court will consider the dual stockholdings of a stockholder for purposes of determining a disinterestedness for Corwin, disinterested for a majority of the minority provisions. Disinterested is written into our statute in 203. The court will consider the stockholdings in all of these issues in deciding what rights attach to the shares in those case. The right to vote or the right to, I was going to say a poison pill or the right to be considered disinterested for purposes of the transaction. It's novel only in that the issue is coming up now in the context of class certification, and it usually, the best I can presume it hasn't come up before is because most class certifications are unopposed, or most class certifications, certainly in the settlement context, are unopposed. So the issue just has not come up. It was argued just recently by the plaintiffs in the recent Tesla case, as Vice Chancellor Slights noted, that the argument was that dual stockholders of Tesla and Solar City should not be considered disinterested stockholders. So our point is that there's certain members who have not been determined of the class, who were not injured in the transaction, and therefore should not be considered part of the class. And I'm going to say it's real money because in this case, it's not a derivative case, it's not a common fund case. It's a case where the damages will be calculated on a per-share basis, and so with 400 million shares at play, the class makes a big difference. And as we cited in the federal case of Cohen, the battle was done because that's where the money is, and the battle over the size of the class is because plaintiffs, naturally, want as big a class as possible. And as the court said for the in terrorem effect that even a weak claim on a very large amount of shares has great settlement value. So we are here because it is in our client's best interest that the settlement class, that the class, is as limited to only people who allegedly, arguably would have been interested, would have been injured in the transaction. And as the Supreme Court said in the Witt case, the issue then comes down to there has to be a fact of injury exists. And in Witt, the Supreme Court reversed the trial court, where the trial court had certified subclasses which included people who the court said had not been injured, and in Witt it had been people who were owed IPO shares. The obligation of the company was to give them IPO shares, so their claim of damages was they did not get the IPO shares that they should have gotten. The Supreme Court said, well, you can't certify a class that broadly because class members who might have sold at a loss had they been allocated the IPO shares were not injured, in fact, by any alleged denial of an allocation of those shares. So what the court recognized was, in the class context, that there's people who are injured and people who are not. If we just take the issue of Detroit claims to be representative or typical of the class. Detroit has a preponderance of Trans-Canada stock. And if Detroit was to bring that claim as solely Detroit, there would be a valid defense that they suffered no damages, and the court would have to decide that issue, and as far as I know, the court has not decided the issue of, in a merger like this between two public companies. The court has simply not decided that issue. But the court is now confronted with that issue on class certification. Everything else flows from that as far as the issues on a certification under 23A and 23B and B, 1B2, B3. And B1, B2, B3. So if there are people out there who own shares who weren't damaged, that means under B1 that it's not the same. All the stockholders are not entitled to the same, which is B1 they all suffer. They all have the same liability and damages. It's not B2 because this is not an injunction or declaration case. It's B3, which is people have different amount of damages. And then the question is predominance. Is the issue predominant between the dual stockholders and none? And so I would suggest to Your Honor that this is, in fact, assuming Your Honor does not rule as a matter of law that that the Detroits of the class simply do not suffer, or did suffer damages or did not, rejects as a matter of law that in this type of transaction, you will look at the dual holdings. Assuming that that is a viable claim that the court is not deciding, then we have the issues of ascertainability, and that is, we're not here to blow up the class action regime in Delaware. In fact, we believe we're applying the class action regime in Delaware. Class action's obviously beneficial that people can aggregate small claims into big classes, but they can't over-aggregate. So when you have the issue here of ascertainability. So on one hand, if you say it's too difficult to ascertain who actually was dual stockholders, then you can't certify a class because it's unascertainable. On the other hand, if at the same time you are ascertaining the stockholders who are actually injured, so the stockholders who received a merger, who were stockholders as of July 1st at the same time through the same process, you're ascertaining what their stockholding was in Columbia, you would use the same process to ascertain what their stockholdings were in Trans-Canada. And that is assumed by the court in some of the cases. I will call that, for shorthand,
The court.
Before you move on to that, let me just ask a couple things. You've said today, and you've said in your briefs that you don't view this as a common fund case. Can you elaborate on that?
Attorney Lesnar.
Sure. The settlement is a common fund case. It's different than the class. The class is, whatever damages are in the class are based on if Your Honor were to decide that there was some incremental amount above 25.50 that was owed to the stockholders. Say it was cents. They owe 15 cents more. Okay, it would be cents times the eligible share for the stockholders who are entitled to it. So it's different than the settlement where the settlement is simply a lump sum to be decided who is to allocate. And I'll talk about that when we're arguing the settlement part.
The court.
The math is going the other way. I guess part of why that seemed incongruous to me is because certainly whenever there is a fee petition in that setting, The plaintiff says, I created a common fund, and the common fund is equal to value times number of shares participating. So it sounds like you're focused on the directionality of the math in terms of the per share, starting with the per share number and ending up with an aggregate, rather than going the other direction.
Attorney Lesnar.
So it's different, Your Honor, in the, I'll call it the litigation class versus the settlement class. The settlement class is a common fund. The settlement was, here's $79 million, we want our releases rightfully, and you can distribute it because we don't have an interest anymore in how it's distributed. TransCanada has an interest in how it's distributed, but I'll discuss that when we're talking about the settlement. But it's different for the litigation class because the measure of damages, as their own expert, Mr. Meinhardt, calculated, it's simply how much more per share the plaintiffs claim that TransCanada should have paid times the amount of the eligible shares.
The court.
How would you feel if, instead of viewing it that way, it was presented essentially as an enterprise value calculation for the company or an equity valuation for the company? Because that's really what the per share number is a proxy for. There's no magic to 25.50. It's 25.50 because that works out to an aggregate price that someone's willing to pay.
Attorney Lesnar.
No, I would disagree with that proposition because their cause of action is a fiduciary duty breach that's owed to the stockholders. The stockholders were paid 25.50. The claim is they should have been paid some amount more than 25.50. It's not an appraisal where the measure of damages is you're entitled to the enterprise value at some proportion. This claim is on behalf of the stockholders that, whoever the eligible stockholders are, that they were damaged because they got 25.50 and something less. It's not.
The court.
Think back to your framing of the core claim as whether the defendant fiduciaries achieved the best price in a sale of the company. The issue is whether they could have held their fiduciary duties in selling the company for which they got an aggregate price.
Attorney Lesnar.
Your Honor, I would say that the case law is, in terms of Revlon, it's whether the directors who owe the fiduciary duty to stockholders, attempted to get the best price reasonably available for the stockholders. It's not in an aggregate level where they attempted to sell the company. It's what they did to get the best price for the stockholders. There could be other constituents here in a merger. There could be bondholders, deb holders. There could be other kinds of constituents. The Revlon duties are owed to the stockholders.
The court.
It seems to me there's a circularity problem in terms of excluding the Detroits of the world from the class in terms of an actual liability setting. And what I mean by that is, imagine a situation where TransCanada does have to pay a judgment. That judgment transfers over to the plaintiff side, the plaintiff class side of the ledger. The Detroits of the world, who own more shares in TransCanada, indirectly bear the cost of that judgment, but they get none of the benefit of that judgment. So effectively, as a result of TransCanada having to pay the judgment, they get harmed by the litigation, but they've been excluded from the class, and so, therefore, don't get whatever the true-up would be. Why isn't that a problem for your approach?
Attorney Lesnar.
Because it really just goes to who suffered the harm. Now, we're very narrowly focused on this, and that is who were the dual stockholders at the time of the transaction. So we're not asking to look and see what their future holdings was of TransCanada. We're focused very much on the transaction. And so if Detroit was not harmed by the transaction because they were a net benefit, then they have no entitlement to a judgment in the first place.
The court.
Look, I understand that step in the argument, and I'm asking you to take the next step and think about the position Detroit is in a world where TransCanada has to pay the judgment. Your premise that Detroit has benefited from the transaction, the math isn't necessarily going to work anymore because TransCanada has now had to pay something that you have to subtract from whatever Detroit's share of the benefit was.
Attorney Lesnar.
I don't think, when you say Detroit's share of the
court.
Using Detroit as a proxy for someone you're excluding from the claims. At the end of this, imagine a world where TransCanada only has 100 shares. TransCanada has to pay a judgment equal to $100. Your world is one where I look through TransCanada to the stockholders. So each one of those stockholders now is attributed $1 less value because TransCanada has had to pay the judgment. Why doesn't that potentially upset the calculations that we used to figure out whether they would be excluded from the class in the first place?
Attorney Lesnar.
I think what Your Honor is saying is that the premise of that is that TransCanada is paying some lump sum.
The court.
Yes.
Attorney Lesnar.
And sort of what the settlement is. Okay.
The court.
No. The premise is that we actually get to the end of the day and somebody's going to win. somebody's going to lose. In the hypothetical where you guys win, we don't have this problem. In the hypothetical where the plaintiffs win, your guy has to write a check. And what I am interrogating or trying to interrogate is how your model works from the stockholders you have excluded from the class in a situation where TransCanada has to write a check.
Attorney Lesnar.
Yes. So I guess the easiest thing would be that there is no final judgment until there is a determination, a factual determination, of which stockholders were injured or not.
The court.
Why is that the easiest thing? What I'm suggesting to you is there's a circularity problem because the judgment itself is going to affect the relevant allocation of injury.
Attorney Lesnar.
Correct. So what the court, if there was a finding, the
court.
That's the only situation where this matters. That's why we're talking about it.
Attorney Lesnar.
Okay. The court's judgment would be, I assume, similar to what happened in rural, metro, where it was a marginal increase in price times the eligible shares. The only problem I see is if the court were to say that at that time that the Detroits of the world are eligible shares and hence they're entitled to the dollars. It's not a problem. That's an ascertainability problem. If I understand your hypothetical, and I may not be.
The court.
Yes, let me try again. What you're envisioning, as I understand it, is a world where, at the deal price, somebody is a net gainer because their TransCanada stake exceeds the value of their Columbia stake. Fair so far?
Attorney Lesnar.
That is, in the transaction itself, yes.
The court.
To calculate whether someone is a net gainer, you're going to use the transaction price. Fair so far?
Attorney Lesnar.
What the stockholder was paid in the transaction, yes.
The court.
In a world where your client has to write a check, the transaction price effectively changes because TransCanada is making a payment over to the plaintiff class. Again, with me so far?
Attorney Lesnar.
Oh, I see what you're saying. I think I see what you're saying, Your Honor.
The court.
So that should change the math as to who's in, who's out, and at a minimum, if I have excluded people based on the math at the transaction price. Those excluded people, they're now bearing the cost of the judgment without the offsetting value that they would get if they were part of the class.
Attorney Lesnar.
I think what Your Honor is saying is at the time of the transaction, whether dual stockholders should be paid or not, and we're not arguing that. We're not arguing that all the stockholders weren't entitled to 25.50. So at the time of the transaction, the stockholders received the money. The stockholders received the merger consideration, and we're not arguing that, from that merger transaction itself, it should have excluded dual stockholders.
The court.
I'm not positing that.
Attorney Lesnar.
So we're not, Your Honor, as far as the time difference, where we're saying just look at the people at the time of the transaction, and not 6 years later, like right now you're saying.
The court.
I get that too. We're freezing the universe of stockholders as of the time of the judgment.
Attorney Lesnar.
The judgment, yes.
The court.
I'm sorry, as of the time of the transaction.
Attorney Lesnar.
The transaction. Okay.
The court.
All right. Look, we'll move on. I'm not successfully communicating my point, which may be likely due to my own inability to communicate.
Attorney Lesnar.
I'm sure it's mine, Your Honor.
The court.
No, you were going to shift on to the individual appraisal claimants.
Attorney Lesnar.
Yes. So, Your Honor, there's no question that the 19 stockholders who owned the close to million shares, who were actual petitioners in the appraisal case, they are bound by the rulings of the appraisal case. So the question is, and then, again, we're just focusing on those particular stockholders because Your Honor has already held at the motion to dismiss stage that stockholders who are not part of the appraisal are not bound, and so therefore focusing solely on the appraisal petitioner stockholders. So I don't think there's any question that the appraisal petitioner stockholders are bound by the rulings in the appraisal. The same way Your Honor has ruled on the partial summary judgment motion that TransCanada is bound by the law and facts as found in the appraisal, but Smith and Skaggs were not. Now so. And in the partial summary judgment ruling, Your Honor found, in the context of the appraisal decision, where the argument was made, that the court can give credence to the 25.50 because it was approved by an overwhelming amount of Columbia stockholders. And the court rejected that as an indicia of fair value because the court ruled that there were fiduciary duties of disclosure violations and therefore the court could not rely on that. The same way, so our argument is, the same way the court held that it had found a breach of fiduciary duty violation in the appraisal, in that context, and that the parties to it are bound by that ruling, the same way the petitioners in the appraisal case are bound by the court's holdings that the sales process was sufficient to rely 100% on the appraisal price. And we are aware of no cases where a sales process that was the subject of a breach of fiduciary duty could be relied upon for 100%. It would be what we could say is a Tier 1 or Tier 2 process. Therefore, you could not have. The necessary holding of the appraisal case was that there was the sales process, which is relied upon 100%, could not be the product of a breach of fiduciary duty. And the only duty in that case is the sales process, so it was your Revlon duties, the duty to attempt to get the best price reasonably available, and that process had to be within a range of reasonableness. And so the court, having relied on the sales process 100% for the sales price, for the 25.50 fairness, is a necessary implication that the stockholders who were the petitioners in the appraisal case are bound by that ruling. That is the premise on this motion for class action certification, that those stockholders should not be included.
The court.
And, again, I take your point that the appraisal petitioners would be bound by the factual findings in the appraisal determination. But how is your argument that the factual findings in the appraisal decision foreclose any breach of fiduciary duty claim different from the argument I addressed at the motion to dismiss stage?
Attorney Lesnar.
It's a different context, Your Honor. And the motion...
The court.
How is the argument different? I get that it would have a different implication in that, at the motion to dismiss stage, it would have resulted in the dismissal of the whole case, whereas at this stage, it would only result in the exclusion of the appraisal claimants from the class. But how is the argument different?
Attorney Lesnar.
The argument is different in that in the motion to dismiss, it was an argument based on preclusion, that the stockholders were not bound, all stockholders were not bound, and that Your Honor rejected that and said that they are not precluded from that finding. The next day, in the summary judgment, the court did find that that the appraisal case had found a breach of fiduciary duty, and that the TransCanada, as a party to the appraisal, was bound by that ruling of a finding of a breach of fiduciary duty coming out of the appraisal action. So in the class context, what the court, at least the way I've read it, the court has held that it made a finding of a breach of fiduciary duty in the appraisal action, and that those parties were bound to it. And the necessary implication is the court found in the appraisal action that there was not a breach of fiduciary duty because...
The court.
That's what I want you to focus on. The first part that you talked about is what I'm not fighting you on, and what I said I take your point on. I want you to focus on the second part.
Attorney Lesnar.
Yes.
The court.
Which was also raised at the dismissal ruling, which was the idea that those findings meant there could not be a breach of duty. Why isn't that the same argument that you're making?
Attorney Lesnar.
So, 1, and I'll go. 1, because it applies only to the petitioners, and 2, as we put in our brief, Your Honor, the issue was fully litigated by the petitioners. They took discovery on it. All the stuff we said in our brief, they fully litigated that issue and it was necessary.
The court.
The issue that I'm trying to get you to focus on is the assertion that the fair value finding in the appraisal case was the legal equivalency of a no-breach finding under enhanced scrutiny. Why isn't that the same argument that you made at the motion to dismiss stage and that I already ruled on?
Attorney Lesnar.
Okay. That ruling, to the extent Your Honor ruled that the members who are not appraisal petitioners are, that the court did not find. The court did not go into the issue of fiduciary duty. Okay. That is, I guess, you say, that is not being made in the context of the class certification and...
The court.
Let me just read some text to you. This is from page 2 of the dismissal decision. The appraisal decision held that a sale process was sufficiently reliable that the deal price provided a sound indication of the company's standalone value. The appraisal decision did not determine whether Skaggs and Smith breached their fiduciary duties, nor did it address the claim that the company could have obtained a higher deal price from TransCanada or from a competing bidder if Skaggs and Smith had not acted as they did. I also said the court had characterized the appraisal decision as addressing, and here again I'm quoting, a narrow question, the fair value of Columbia as a standalone entity operating as a going concern. Look, I understand you disagree with those rulings. I understand you think they're wrong, but why isn't that the exact same issue and the exact same argument you're making now? It's just instead of saying that it is a clean winner under either preclusion or remember, you also argued stare decisis, and this would be the stare decisis version. Most plainly, why isn't that the exact same argument that you're now making as a basis to exclude the appraisal claimants from the class?
Attorney Lesnar.
It is, Your Honor.
The court.
So, why do you get to do that?
Attorney Lesnar.
It is the same argument. It's in a different context and it's not on a motion to dismiss.
The court.
Is it law of the case?
Attorney Lesnar.
I don't believe it's law of the case, Your Honor.
The court.
Why don't you believe it's law of the case, Mr. Lesnar?
Attorney Lesnar.
Because the law of the case deals with an issue that was decided, as an issue that was decided as a matter of law in the context of what it was argued.
The court.
Under your view of law of the case, why would there ever be law of the case or fact? Because it's a different motion. It's a different motion. It wasn't a motion to dismiss. It's a motion for summary judgment. It wasn't decided under the summary judgment standard. It was decided under the Rule 12b-6 standard.
Attorney Lesnar.
Even if it was law of the case, Your Honor, we cited law that says that Your Honor can revisit issues prior to a final judgment.
The court.
At least we got to the point where, keep going.
Attorney Lesnar.
In that, just one last point on that so I don't let it stew, and I brought it up before. In the context of the motion to dismiss, it was argued on behalf of different elements on behalf of the appraisal petitioners. In this case, we put in front of Your Honor, on this procedural posture, we put in front of Your Honor all of the facts that they argued the same issue, and that they argued the same issue and the court ruled on the issue in the same way the court may reconsider or consider the class action motion in light of what the arguments were in the appraisal case by the petitioners. And other than that, and if it is the law of the case, it's an issue that can be revisited in the context of the class certification, or it can be revisited at any time before the end of the trial. Okay, and that, Your Honor, was really talk about the issues as far as the broad class, but I think Your Honor takes our point that the class is overbroad because of the dual stockholders, the appraisal stockholders. And once the court were to reach the conclusion that it has to look at these things in determining who the class is, everything else flows through the 23A elements and the 23B3 elements and is simply an application of standard law.
The court.
Thank you.
Attorney Lesnar.
Thank you, Your Honor.
The court.
Do we have a quick reply on this?
Attorney Weinberger.
Yes, Your Honor. Thank you. I'll be very brief. I will note that a number of the arguments I heard are straight out of the objection to the settlement as opposed to the opposition to class certification, and Mr. Lesnar was. Your Honor had asked a question also about TransCanada's assertion that this is not a common fund case or common fund settlement. The objection to the settlement says, explicitly, this is not a derivative case or common fund settlement. So that they have, in fact, made that obviously erroneous assertion. Again, just very briefly on the dual holdings. Again, all answered by Erden. Mr. Lesnar mentioned WIT. WIT is a case involving personal claims, breach of contract, breach of a brokerage agreement, not stockholder claims associated with the property. This notion of looking to other contexts where the court assesses an individual or entity's financial interest, such as in a board vote or a stockholder vote, completely different context. There, the court is trying to determine whether or not to defer to a board decision or to a stockholder decision. Perhaps the court's considering whether or not an officer or director's conduct has been called into question by some interest they may have. That's not the same as the interests of other stockholders. I made the point before about burden. TransCanada, Mr. Lesnar, they haven't identified the individuals in the class who actually have these supposed cross-holdings. In straight path, at least, defendants, and we undermined this. Mr. Van Quawigan deposed the expert there. They at least came forward with data, with information purporting to show that there was substantial overlap among the classes.
The court.
Look, it's got to be, right? This is part of the reason why, even though there's the professed view that this wouldn't change anything. I mean, these are two widely held companies. We know about the levels of cross-ownership in the market. I mean, there's got to be a lot of cross-ownership. That's why this would essentially be a recurring issue. What also no one has shown me is why there's anything unique about TransCanada and Columbia that would not make this something that would be a far more wide-reaching precedent. What's your take on that? You don't think that they're not cross-holdings, do you?
Attorney Weinberger.
No, I would presume there are cross-holdings. I mean, we know the data generally with diversified investors and the way mutual funds and other institutional investors invest. If the rules they are advocating are to be the rules in Delaware, we are likely done with the class action mechanism, which becomes so cumbersome that it's almost unmanageable. At a minimum, we revert back to the claims process that
The court.
Yes. Again, it certainly becomes massively cumbersome. Essentially, what you have to do is you have to do a mid-case claims process to figure out who's going to be in the class. So think how expensive an end-of-case claims process is, or a settlement claims process is, and all that that requires. I mean, one can say with a straight face that class actions wouldn't be gone, but I guess what I don't want to do is have you say to me, oh, they haven't come forward with evidence that there's cross-ownership, and create the impression that the reason why it would be okay in this case is because there's not likely to be some cross-ownership. I think that would be closing our eyes to the fact that, as you also point out, there's got to be substantial cross-ownership. I mean, I don't know what the level is, but there's got to be some.
Attorney Weinberger.
And there's nothing unique about this case. In that regard, this is a garden variety merger, and strategic mergers happen all the time. Folks in the same industry buy one another.
The court.
Anyway, I interrupted you because I just didn't want to go down the road where we were presuming to engage on a basis where we were pretending that there really wasn't likely to be cross-ownership because nobody had come forward with plain evidence of the magnitude of cross-ownership. But I don't want to throw you off in terms of whatever else you wanted to say in your reply.
Attorney Weinberger.
Well, I'll only make one more point on the cross-ownership, and that is with respect to Detroit specifically, because I addressed our affirmative points on adequacy when I stood up at the podium before, but the notion that having a nominally larger dollar stake in an acquirer that is 3 times the size of the company being acquired, that somehow creates a conflict or whatever, create any type of right of offset, we just fundamentally disagree with that. And, certainly in terms of, adequacy in this case, again, Your Honor, I'd say the best objective evidence here is, what have these stockholders done today? Is there any suggestion, as TransCanada says in its papers, that Detroit is somehow adverse to the members of the class, or has acted adversely at any time? To the contrary, basically all the history shows advancing the interests of the stockholder class. One last point, Your Honor, I just want to make on this. The notion of the impact of the appraisal decision on factual findings made in the appraisal trial with respect to appraisal petitioners who may be members of the class, in thinking about it more. I mean, as I understand Seed v. Technicolor, the stockholders have a right to elect their remedies following a trial of all claims. There has not been a trial of all claims here, and as I mentioned before, there's not been a trial of all claims because TransCanada opposed a trial of all claims. So I want to somewhat walk back what I said before, having considered it more under what I understand, to still be binding precedent in Delaware, that is an appraisal petitioner's right to elect whether or not, following a trial, that stockholder wants to have some other remedy. And I think that's sort of consistent with Orchard, where there was a trial, and the appraisal petitioners who were included later in the settlement class were effectively topped up to receive the remedy that the fiduciary plaintiffs had secured in the class action case. Unless Your Honor has any questions, that's all I have.
The court.
All right, thank you. We've been going for 90 minutes. I appreciate everyone's presentations and patience on this issue. Let's take a 15-minute break. And when we come back, I think I'm going to go ahead and give you an answer on this motion, and then we'll move on to the settlement approval motion. Thank you, everyone. We stand in recess until 1:00.
Recess taken from 10:45 a.m. to 11 a.m.
Welcome back, everyone. I appreciate your time and your presentations this morning and your briefing. We have 2 matters to address this morning. First is the motion for class certification. The second is the approval of the settlement. I'm going to go ahead and address the first question now, and that's the motion to certify class that would be used to litigate this case going forward. It's not a class for all time. It can be modified for good cause shown. Absent modification, it's the class that will be used to litigate this case to judgment. In terms of the factual background, I'm not going to spend time on that. I would refer people to a decision dated March 1, 2021, which I think of as the dismissal decision, that denied a Rule 12b-6 motion to dismiss. There's also background in a decision issued August 12, 2019, which I think of as the appraisal decision, which was a post-trial decision in the appraisal action. I'm also not going to go through chapter and verse on the language of Rule 23A and B and what they say. I'll let you all, in the interest of time, look up those things on your own if anybody wants to examine the actual text. So what I'm asked to certify today is a class that is defined as all public stockholders of Columbia at any time from July 6, 2015 through and including July 1, 2016, including any and all of their respective successors in interest, successors, predecessors in interest, predecessors, assigns, and transferees. And then there are exclusions for the defendants, parties associated with TransCanada and their affiliates. This is a standard class definition for an M&A case. One could find literally thousands of settlements agreeing to a definition like this. One could find, I suspect, I don't know what the order of magnitude is, but I would bet it's north of 100, certainly high double figures, using these types of definitions for litigation classes. So I start from that premise that there is nothing exceptional in any way about the proposed definition. TransCanada has objected to the definition. The opposition struck me as a little bit like coleslaw. They chopped up a lot of cases on class actions from a lot of different contexts and pulled in quotations, then threw it all together into one somewhat slimy bowl of stuff. I think their arguments rest on very basic misunderstandings about how a corporate class action works and how this court has adjudicated and certified classes for quite some time. TransCanada's objections can largely be divided into three categories. The first is problems with the class definition as to its breadth. The second is with problems under Rule 23A, and then the third is problems under Rule 23B and the appropriate mechanism for certification. One of the principal themes throughout TransCanada's opposition is this concept of cross-ownership. TransCanada starts from the plaintiff's premise that TransCanada aided and abetted a breach of fiduciary duty by Smith and Skaggs that resulted in TransCanada paying too little to acquire Columbia. It then says, well, that necessarily must mean that TransCanada's stockholders benefited from that outcome. TransCanada then envisions a world in which the court looks through TransCanada, effectively piercing the veil of TransCanada to determine how much TransCanada stock each investor in Columbia owned. The court then nets out the alleged benefit, and if the investor owned more TransCanada stock such that it was a net benefiter rather than a net loser, then those stockholders are excluded from the class. Essentially, TransCanada maintains that the class can only include net losers. I think this notion of certifying a class based on net losers and net gainers is conceptually wrong in many ways. There's nothing unique to this case that would warrant it. There is no material difference that would distinguish this case from the other cases in which this court regularly certifies classes of the type proposed, and does so under B1 and B2. Does so under B1 and B2. As I noted, the premise requires looking through TransCanada to assess its individual stockholders. It also treats the benefit as something that those stockholders would be entitled to receive, when in a situation where the net loser, net gainer concept becomes pertinent, what there would be is an adjudicated fiduciary wrong. Most importantly, I think it ignores the distinction between personal claims, which individuals hold, versus claims associated with a property right. So, in other words, claims that persons hold in their capacities as stockholders. B3 classes are associated with the former. B1 and B2 classes are associated with the latter. The TransCanada approach is a B3 individualized injury approach that looks at the individual. One needn't stop at cross-ownership. One could look at the individual in all respects, as one does in other settings, to see if they were harmed or helped, rather than simply looking at that person in their capacity as a holder of shares, which is what Delaware law does. So let's start with the objections to the class definition. As I noted at the outset, it's a standard class definition. TransCanada objects that the class is overbroad because it includes all public stockholders from July 6, 2015, through and including July 1, 2016. TransCanada professes not to understand why that definition would be appropriate. It is customary to start with the beginning of the time period that's potentially covered by the sale process and end with the closing of the merger. Now, I'll say that's not required, and it's not required for Delaware law purposes, because, as we know from the Delaware Supreme Court's decision in Erden, the claims that are being litigated in this case, and which are generally litigated under Delaware law, travel with the shares. So folks who were owners at the start of that class period, but not at the end of the class period because they sold, gave up their shares and sold them to the new owner, the right to bring and benefit from these claims traveled with that transaction. Likewise, somebody who dipped in and dipped out of the stock during the class period, that person acquired their shares, would be entitled to be a member of a class asserting the Delaware claim as of the time they were an owner, and then dropped out again when they sold their shares. What this means is that the Delaware law claims for breach of fiduciary duty, whether they be the sale process claims or the disclosure claims, ultimately end up being held by the owners of the shares at the effective time. The class period only needs to cover the shares at the effective time. A temporally broad class definition in a Delaware case only benefits the defendants. It doesn't change the quantum of damages because of this factor of claims passing with the shares. What it does is it gives broad res judicata effect to the judgment, such that if the defendants prevail, great, a large class, a temporally broad class is bound. If the defendants don't prevail and they have to pay some money, okay, but at least a temporally broad class is bound. So it is counterintuitive for the defendants to come in and say, no, we want a shorter class period. This isn't something that affects the count of shares in the class, which is something that the net loser net gainer concept addresses. The time period is something that, again, I don't see any basis for it to benefit TransCanada, but I think what TransCanada is here to do is make whatever arguments it can, and this is an argument that it had, and so it made it. So I am going to acknowledge that TransCanada has a valid point. The only stockholders that need to be in the class for purposes of the claims that will be litigated to judgment are those stockholders at the effective time. So I am going to modify the class definition to refer to the public stockholders of Columbia as of the effective time on July 1, 2016, subject to the exceptions that were in the original definition. The next argument that TransCanada makes is that the class impermissibly includes 19 Columbia stockholders who were parties to the appraisal action and are bound by the appraisal decision. One consequence of the Delaware Supreme Court's ruling in Seed v. Technicolor is that a stockholder can pursue an appraisal and a breach of fiduciary duty claim. The only limitation is that the stockholder can't recover duplicative remedies. In Technicolor, the Delaware Supreme Court recommended deciding the breach of fiduciary duty case first because that remedy is likely to be broader and could moot the appraisal case. At a minimum, the two are usually tried together. Here, that's what the plaintiffs sought to do. TransCanada resisted that approach and obtained a ruling from me saying that they did not have to try the fiduciary duty class with the appraisal claim. So we did the appraisal claim first. There's nothing wrong with including the appraisal petitioners in the class. The plaintiffs have cited the Orchard Enterprise cases, which I think are on point. What I do think is a fair point for TransCanada to raise is that it is likely true that as to factual findings made in the appraisal case, those factual findings are binding on the parties that actually litigated that case. Thus, the 19 Columbia stockholders who actually litigated that case to judgment, I think it is true, as a matter of issue preclusion, are bound by factual findings in that case. Now, TransCanada takes the next step and asserts that those appraisal members can't be part of the class because their claims for breach of fiduciary duty arising from the sale process, their Revlon claims, are barred based on the findings that were made in the appraisal case. This is the same argument that was made as to all plaintiffs at the motion to dismiss stage. It was advanced as a matter of issue preclusion. It was also advanced as a theory of stare decisis. The court rejected that argument. I quoted earlier from pages 1 and 2 of the dismissal decision, which summarized the court rejecting that argument. That's law of the case. I understand that the defendants disagree with it. That's their right. They sought interlocutory appeal on that point, so there's no question that they disagree with that outcome. But for purposes of this proceeding, that's a ruling that I have made. Now, the narrower point, though, that factual findings could be binding on the appraisal petitioners is a meaningful one. So the question is how to proceed. It may not make any difference. I may make the same factual findings that I made in the appraisal case, or there might be factual findings that differ but which lack any legal significance. So my view is that the best course is to try this case. After I've issued a post-trial decision, there can be an opportunity for the parties to address whether the court has made factual findings that A, differ from the appraisal action, and B, have legal significance as to the outcome. If there are such factual findings, then I would have the ability to create a subclass consisting of the appraisal claimants. I don't have to do that now. I can do that once we know whether that's a real problem or just a hypothetical problem. Alright, so those are my rulings on the class definition. I'm now going to use that definition to analyze Rule 23A and B. For purposes of Rule 23A, 1, numerosity is plainly satisfied. There were over 400 million shares of Columbia common stock outstanding and entitled to vote as of the record date. It's reasonable to infer that that same amount of shares was outstanding at the effective time. That is a quite large number, sufficient to satisfy Rule 23A, 1, particularly when the record reflects that those shares were held by approximately 22,000 holders of record. The next question is whether there are common questions of law or fact under 23A, 2. This element is satisfied where the questions of law or fact linking the class members are substantially related to the resolution of the litigation. That's from the Delaware Supreme Court's decision in the Leon Weiner case from 1991, and the Marie Raymond Revocable Trust decision from 2008, This court held that the commonality requirement was met when the plaintiff alleged injuries to all investors stemming from a common course of action by defendants, including an alleged breach of the defendant's fiduciary duties owed to the class in connection with the transaction at issue in that case, which was an exchange offer. It's true that there can be some cases where common questions of fact sufficient to certify a class do not exist. This is not one of them. This is a standard M&A deal case. From a class certification standpoint, there's nothing different. There's nothing unique. The defendants took action that affected the stockholders proportionally based on their ownership of Columbia stock. All of the legal issues in the case are common across the holders of the common stock. Those questions include whether Skaggs and Smith breached their fiduciary duties in connection with the merger, whether TransCanada aided and abetted Skaggs and Smith's breaches of fiduciary duties, and whether the sell-side stockholders are entitled to damages. Now, this is one of the main places where TransCanada trots out its net losers, net gainers theory. TransCanada asserts that the class would need to be significantly pared back to exclude net gainers. I think that this argument treats the class as if this was going to be a 23(b)(3) class comprised of individuals like mass tort victims or antitrust plaintiffs, where we'd have to work through each person individually to assess the degree of harm. That's not how these claims work. As I've already stated, under Erden, the rights being asserted travel with the security. They exist because of the person's capacity as a holder of the shares. One doesn't look to the person as an individual. One doesn't consider, for example, as one would do if one were a trustee considering the interests of one's beneficiaries, whether that person needed money because of their age or sickness or financial situation or children or employment status, or any of these things attendant as to that person's individual capacity. One might indeed, if one were a trustee, take into account someone's other investments when making a decision as to what to do in the best interests of that beneficiary. That's not how corporate fiduciary duties work. Fiduciary duties are owed to the corporation and its stockholders, and what that means is people in their capacity as owners of the shares. We don't ask whether those people needed money because they lost their jobs. We don't ask whether those people might benefit from a longer holding period because they're really wealthy and don't need the cash right now. We don't ask whether those people might really need to sell because they actually had some medical tragedy and need the money. What our cases say is that the directors have a fiduciary duty to strive to maximize the value of the equity. There's actually a pretty humorous law review article on this. I think it's humorous. It's by a fellow named Daniel Greenwood, and it's from 1996, and it's in the Southern California Law Review. It's called Fictional Shareholders for Whom Are Corporate Managers Trustees Revisited. He goes through this analysis from the point of view of satire to try to say that it's silly for corporate law not to think about the individual interests of persons in the way that I've just articulated. But sometimes satire can be insightful. Think about Jonathan Swift. What he actually shows is that this is really how we think about these things. So one of the things that we don't do is we don't look through to individualized damages based on buy-side holdings, which would require ignoring the corporate separateness of the acquirer and looking through to the effect at the time of the deal on the individual stockholders. Now, that doesn't mean that we have to blind ourselves to cross-holdings in other contexts, and I'm going to get to 23(a)(4) in this case. Cross-holdings can create incentives, and so in a setting where incentives are important for decision-making, one can consider the decision-maker's incentives. That's why, as counsel points out, we have considered cross-holdings when we think about things like whether individual directors are disinterested and independent, or who should be included in the definition of disinterested and independent shares. We think about these things in those contexts because of their implications for approval and what the approval decision means. We don't, at least we never have, and I don't think we should, do that same type of look-through for purposes of a damages analysis in a corporate case involving A, B1 or B2, class corporate case involving A, B1 or B2 class, where the claims arise and are attached to and travel with the shares and are therefore reflective of harm to the person in their capacity as a holder of the shares, not harm to the person in their capacity as the holder of inalienable rights to life, liberty, and the pursuit of happiness. Here, liability can be determined on a class-wide basis. The issues can be determined on a class-wide basis. If there is a remedy, it will run against TransCanada, not against its stockholders. As I tried to inquire, but I think I did so inaptly and ineffectively, is how the fact that TransCanada pays the judgment, if indeed there is a judgment, because that's the only setting that really matters, and would work through indirectly to the cross-owning stockholders, and effectively inflict harm on them. That is a factor that doesn't seem to me to be taken into account in the objection that TransCanada has raised. So I do hold to be clear, and I think there was an invitation to be clear on this. I do think, as a matter of law, this is not something we do. I'm not making this finding based on the idea that there isn't cross-ownership. I think that would be a counterfactual assumption. I think there likely is cross-ownership. I think there likely is cross-ownership in virtually every deal case involving two publicly traded companies. And so I think that this is an issue where a change would have quite significant policy ramifications. All right, now, let's talk about Rules 23, A3, and A4. Rule A3 requires that Rules 23, A3, and A4. Rule A3 requires that the claims or defenses of the representative parties be typical of the claims or defenses of the class. For all the reasons I've now explained, the lead plaintiff's claims and injuries are typical. They are viewed for purposes of this action as sell-side stockholders. It is not a unique defense or disproportionate defense for them to have a potential buy-side interest, or in the case of Detroit, to have an actual buy-side interest. So typicality is satisfied. Now let's talk about Rule 23A4. Rule 23A4 asks whether the representative parties will fairly and adequately protect the interests of the class. This is an inquiry into decision-making. This is an inquiry into whether the class representatives can fulfill their fiduciary duties. It therefore is, in my view, analogous to those settings where we have considered cross-ownership to determine whether directors have a conflict or whether stockholders can be validly included in the definition of the disinterested shares. I do think that it is fair to take into account levels of ownership, and indeed cross-ownership, when evaluating whether the representative parties will fairly and adequately protect the interests of the class. TransCanada argues here that Detroit can't meet this standard because Detroit is a dual stockholder that owned a substantially greater equity interest in TransCanada than in Columbia. TransCanada argues that Detroit's interest was 7 times its interest in Columbia, that it therefore should be excluded from the class and can't be an adequate or typical class representative. I've already explained why I don't think Detroit has to be excluded from the class. I have considered whether this level of interest should be a problem for A4, and I am not at all convinced that it is. Would I take it into account at some level? Yes, I would. Would I take it into account potentially when I was assessing a leadership structure and choosing between competing counsel? I might think about it there too. I don't think this is irrelevant, but I don't think it is a factor in this case that warrants making a finding of inadequacy under Rule 23A4. I think the plaintiffs and their counsel have proven quite graphically that they are diligent litigators who are pursuing the best interests of the class. They've been doing so for quite some time against significant odds, and they have obtained in this case a settlement which I haven't yet approved, but which is indicative of their ability to act on behalf of and in the best interests of the class. So having taken into account the allegations about cross-holdings, I do find that Rule 23A4 is satisfied. TransCanada has further argued that Detroit can't serve as a representative plaintiff because its Rule 30B6 representative was unprepared to answer basic questions regarding notice topics. I didn't like the quality of the testimony that the 30B6 witness gave. He should have been better prepared. He should have known more. But I don't think the answer is to disqualify Detroit or plaintiff's counsel or hold that 23A4 isn't met. I think that when I take into account what I have seen, and particularly witnessed in terms of the litigation conduct and the vigorous efforts that the plaintiffs have put in, 23A4 is met. I'm also not moved by the argument that neither Detroit nor Mississippi could adequately represent the class because they failed to give informed consent to continue being represented by Bernstein-Litowitz based on the order issued by the district judge in California. I think that's, in the first instance, a question for Detroit and Mississippi. It's not clear to me why TransCanada has the ability or should be able to argue that Detroit and Mississippi needed to be protected from their own decision-making in this regard. Now, what I do think about is whether this could evidence some type of compromise decision by Detroit or Mississippi and therefore an inability to oversee counsel that would lead to counsel not doing an effective job. And just as I've already said, I think that when viewed in the totality of the circumstances, that's not a point that moves me. So from my standpoint, all of the Rule 23A factors are satisfied. The next question I have to deal with is certification under Rule 23B. There are 3 options, B1, B2, and B3. TransCanada argues that if the class can be certified at all, it has to be certified under Rule 23B3. That is contrary to our law and a number of well-reasoned decisions by distinguished members of this court. Chancellor Allen addressed the issue at length in 1991 in the Heinsohn case. He also talked about it in the mobile communications case. Chief Justice Strine, when he was a member of this court, addressed it in the Turner v. Bernstein case. The The defendants have cited a decision by then Vice Chancellor Steele in Dieter v. Prime that took a different approach. That decision predated Turner, and I don't think is persuasive. I think if there was any doubt about the availability of 23B1 and B2 certification, the availability of 23B1 and B2 certification from the decisions of this court, we have a statement from the Delaware Supreme Court in 2012. I'm going to read it to you. Delaware courts repeatedly have held that actions challenging the propriety of director conduct in carrying out corporate transactions are properly certifiable under both subdivisions, B1 and B2. The availability of potential damages alone does not automatically require certification under Rule 23b-3. That's from the Solera case. Certification under this court's precedents is plainly warranted here. A class is properly certified under Rule 23b-1, where the case involves one set of actions by the defendants creating a uniform type of impact upon the class of stockholders. That's a cleaned-up version of a quotation from the Turner decision by then Vice Chancellor Strine. That's exactly what we have here. What our cases normally do is certify under 23b-1 and also say that 23b-2 is another vehicle. That's what I think as well. The plaintiffs seek class-wide declaratory relief. That can be a vehicle for 23b-2 certification under our precedents, so I can certify under both 23b-1 and 23b-2. So the bottom line is I'm certifying the class. The one modification I'm making is that I'm certifying the class comprising the stockholders as of July 1, 2016 at the effective time, and I'm acknowledging the possibility that it may be necessary at a later time to think about the appraisal claimants once we know whether that issue matters or not. I appreciate you all bearing with me. Any questions on that before we turn to the settlement? It's technically the plaintiff's motion, so I'll start with you.
Attorney Weinberger.
No, Your Honor, no questions. Thank you.
The court.
Defendants?
Attorney Lesnar.
No questions, Your Honor.
The court.
Great. Thank you so much. All right.
Attorney Van Quawagen.
Good morning, Your Honor. Jeroen Van Quawagen from Bernstein Litowitz, on behalf of the plaintiffs. Your Honor, I'm proud to stand here, very proud of this settlement. The question before the court is whether the settlement, plan of allocation, and the fee are fair and reasonable, and we respectfully submit that they are. Your Honor saw from the papers that over 100,000 Columbia, the pipeline stockholders, former stockholders, received notice, and we know that they paid attention because when there was an error in the signing, in the sending of the notice they started calling us, and we corrected that mislabeling of the notice. So it is not the case that this notice just went into the garbage and nobody paid attention. People were actually paying attention.
And after they paid attention, no former stockholder came forward and said, "We object to the settlement, we object to the plan of allocation, we object to the fee."
And we respectfully submit that there's no reason to do so. When you think about the settlement, it's a $79 million settlement, one of the largest settlements against individual defendants with respect to Revlon claims. One of the largest partial settlements that I think has ever been presented in this court, and as Your Honor saw from the papers, clearly the result of hard-fought litigation against well-skilled adversaries and the result of hard-fought negotiations. I have deepest respect for the Wachtel firm, Mr. Savitt, Mr. Yavitz. These were not easy negotiations, I can assure Your Honor. So respectfully, we honestly believe this is one of the best settlements we could have achieved at this point in time. We are very proud of it. When you think about the plan of allocation has been consistently applied like this since Dole and PLX and Stars, and it has been consistently used in this court since those cases. And in the past, there have been objections to that kind of plan of allocation from former stockholders. I remember vividly an objection to the allocation in Stars from a former stockholder who said, this system where you have direct deposits don't make sense, and Vice Chancellor Glasscock overruled that objection. And the reason I think fundamentally is the acknowledgement that no plan of allocation is perfect. When the choices are between a claims-made process and a direct deposit, there is no perfect answer. The claims-made process has significant flaws. I do securities litigation in addition to litigation in this court, and Your Honor earlier today alluded to the cost of administering those plans. But in addition to that, many small stockholders never get paid. They don't fill out the form because their holdings are too small or because of some other reason that I don't know. Whereas here, in this court, the plan of allocation ensures that all stockholders as of the effective date, or virtually all of them, will get paid, which I submit, respectfully, is a significant benefit of the system that this court has created. Now, again, No former Columbia stockholder has objected to this plan of allocation after the court-approved notice went out, which of course describes this plan of allocation in detail. And then finally, the request for fees has also not been opposed by any stockholder. And Your Honor saw from the papers, we respectfully request payment of 23% of the settlement, which amounts to an hourly rate of less than $1,400 an hour, which is far below the rates that this court has approved in the past. So normally I would have stopped there, but, of course, we know that TransCanada lodged an objection. So let me just quickly turn to that, Your Honor. There are 3 fundamental problems with TransCanada's objection. First one is standing. The second one is the assumption that the settlement class must be identical to the litigation class. And the third one is that TransCanada has some right of seat-off, as opposed to a right to a judgment reduction in case the requirements are met. Those are the 3 fatal flaws, Your Honor. With respect to standing, TransCanada is not a party to the settlement, not making any payments, not releasing any claims. They have no interest in this settlement that needs to be protected. And they could have protected those interests if they had any, because we know that TransCanada's counsel reviewed both the term sheet and the settlement stipulation before Mr. Skaggs and Mr. Smith entered into those agreements. That, I think, could end the inquiry, Your Honor. They have no standing to raise any objections, but let's assume for a fact that we're going to entertain those objections. Well, the second fatal flaw is this assumption that the settlement class must be the litigation class, and Your Honor touched on that a little bit during the discussion with my friend Mr. Leonard. There's no legal support that those 2 classes must be identical, and there's a good reason for that. They serve different purposes. When you think about the settlement class, they are the product of a negotiation, and I can tell you, Your Honor, this was a vigorous negotiation between us, on the one hand, and the Wachtell firm on the other, because the settlement class, and the size of the settlement class, ties directly into the release that the defendants are getting, and they are very interested in getting that release. And it's not just them. It's also the insurance carriers that pay for a settlement. And so there's a multi-level negotiation going on at any given time. At this point, I think it's important for me to call out one of my colleagues. His name is John Mills, and he is the person at my firm in our settlement department who is involved in every settlement that is presented to this court where my firm is involved. There's a practice now that whenever we have a settlement in this court, my firm, including Mr. Mills, take the laboring on documenting the settlement for the plaintiffs and negotiating the class releases. And so here what happened was, there was a hard-fought negotiation with Mr. Mills and me on one hand and Mr. Yavitz and Mr. Savitt on the other hand about that particular issue. And, of course, the defendants are interested in getting as broad a release as possible, but we, as shareholder lawyers, take it very seriously that the release should not be too broad and that it should be narrowed and tied to the actual conduct or the merger or the claims alleged, all subject to court approval. That, Your Honor, is a fundamentally different proposition than what Your Honor is determining, like Your Honor just did, whether or not a class should be certified for legal purposes. And we respectfully submit under the authorities submitted by us and also by the supplemental letter that was submitted by Mr. Lafferty that the authorities fully support this practice, and that, when you look at the release here and the claim definition, the class definition here, they are consistent with many settlements that have been approved by this court. The final fatal flaw, I think, in TransCanada's objection is this notion that they have a right of set-off, and that somehow, if there's a distribution that is being paid to the class, that could impact the rights of TransCanada. It doesn't. There's no scenario under which passive class members receive payment of this partial settlement and would have to give it back. There's no scenario in which TransCanada could have some kind of claim against the passive class members who have received settlement. What there is a possibility that following a judgment, and assuming that there is a judgment in favor of the plaintiffs, that TransCanada can make a showing that it is entitled to judgment reduction under Ducata, and that was included in the settlement and it is the law of this court. But that judgment reduction will never result in passive class members having to repay anything or a new allocation of this particular settlement to the passive class members, and that's partially so because TransCanada is not a class member. Your Honor, that's all I wanted to say, unless Your Honor has any questions about this.
The court.
Thank you.
Attorney Leonard.
Your Honor, we don't oppose the settlement. We don't. Our opposition was based on that the plan of allocation should match the litigation class, and we've already made that argument. Other than that, we have no objections to the settlement.
The court.
Translate that for me into smaller words that I'll be able to comprehend better. In terms of the plan of allocation, just spell that out for me a little bit more.
Attorney Leonard.
Our concern was that if the plan of allocation allocated gave money to stockholders who the court did not consider to be members of the class when the time came, if the time ever came, for set-off or reduction, that there could be an argument that we were not entitled to the amount that was allocated to people who were not damaged or who otherwise weren't members of the class. Here I hear plaintiff's counsel saying that the time comes that TransCanada, if it ever comes to that, would be entitled to the entire seat-off of $79 million, that there's not an argument that would be made that if the classes were different, that there would not be a reduction or credit for people who were in the settlement class but who were not part of the litigation class.
The court.
Spin out for me a little bit more the argument that you're making about the allocation problem. I honestly didn't follow it in your papers, and so I need you to help me with it a little bit more as to what you thought could transpire and how you thought it would happen.
Attorney Lesnar.
I'll try to rephrase what I just said, Your Honor. But the concern was that in a settlement that, at the end of the day, under rural metro, if there was a judgment, that TransCanada would get an offset for the amounts that were paid. If the amounts were paid under the plan of allocation to persons who were not part of the litigation class, then there would be an argument that we were not entitled to that offset.
The court.
Yes. And spin that one out for me. What would be the argument there?
Attorney Lesnar.
Well, there might not be an argument, but I could envision the argument that if you pay, say the class was half different, say it was half the people, it was only $200 million for the litigation class but $400 million for the settlement class. I could see an argument, which apparently is not going to be made, that the settlement paid 20 cents a share but the ultimate judgment in the litigation class was 40 cents a share, and so therefore you are only entitled to an offset of 20 cents a share, not the entire million. That's the argument I can envision. It apparently is not going to be made. And
the court.
And the actual issue, the actual class definitions that were being proffered here, that potential risk would exist how under the original class definitions?
Attorney Lesnar.
The risk, as we saw it, was that ultimate damages were going to be awarded on a per-share basis. And so the settlement is a common fund, so it's $79 million among roughly $79 million among roughly 400 million shares, and roughly 20 cents a share. Okay, so the risk was that the litigation class was smaller. Say it was 200 million. Okay. Then the only credit or seat-off or reduction or whatever we're talking about would be 20 cents a share, would be the cents a share from the settlement and not the entire. The court wouldn't. Or there would be an argument that that's all we were entitled to, instead of entitled to the full 79.
The court.
And the potential distinction between the two classes was because TransCanada was arguing that the litigation class should be smaller, right?
Attorney Lesnar.
Yes. And our understanding is that the litigation class should be the same. The same factors as in the litigation class are the same factors.
The court.
For your concern, what you were envisioning was a litigation class that was smaller than the settlement class.
Attorney Lesnar.
Our concern was a litigation class, a settlement class that was greater than the
court.
So I view those two things as reciprocal. If the litigation class is smaller than the settlement class, it strikes me that the settlement class is greater than the litigation class. Are you with me on that, or do you have a different view?
Attorney Lesnar.
Of course.
The court.
Since you made the point of clarifying it, I thought that there might be a divergence that you had picked up that I wasn't following you on, and I wanted to make sure that I wasn't missing a point that you were making. We're on the same page?
Attorney Lesnar.
Yes, of course.
The court.
So why, if you all argued for a smaller class, and you win that and get the smaller class, would you still get the reduction for the full settlement? Why wouldn't it naturally follow that you would only get the lesser reduction?
Attorney Lesnar.
Well, Your Honor, I'm not saying that that's a winning argument. I'm saying that that's a risk. I'm saying that that was a risk, that we would face that argument at some time.
The court.
Right. But what you wanted to be able to do is to say, we got this smaller class, we only have to pay the smaller judgment, but we should still get the offset based on the much larger class that the settlement went out to.
Attorney Lesnar.
Well, not necessarily a class, Your Honor. It's the allocation. So it's our understanding the allocation should be tied to the class, that the people who were getting allocated the money for the settlement should be the same people who are members of the class. And so, therefore, if the plan of allocation gives people money, gives people the $79 million who were ultimately found not to be part of the litigation class, there could be an argument. Not that we think it's a valid argument, but there could be an argument that TransCanada was not entitled to the entire offset but only to the offset of the people who were paid pursuant to the class.
The court.
Yes, I guess I'm trying to understand why you would think you have a claim to the full boat. We've got two types of people in the settlement class, ins and outs, and the outs are the people who aren't in the class that you wanted to achieve, which was the much smaller class, right? So million goes to everybody in the settlement class. What I understood you to be saying is, hey, we, TransCanada, we're going to successfully argue for a much smaller class. We're only going to owe money to this smaller class and therefore pay a smaller aggregate damage award. And yet we want the full offset from the larger. We want the full million. We just don't want whatever was allocated the ends. Why would you get that?
Attorney Lesnar.
Well, Your Honor, that was our position of why the allocation coming out of the settlement should only be to those people who, the allocation, the class definition is derived or is, I'm going to say it's set aside. The real point here is the plan of allocation, because even under their plan of allocation, they were going to be allocating to what we believed was a broader group of stockholders than we had argued for the class certification. Which is why our understanding is that the litigation class should be the same as the allocation class because ultimately, at the end of the day, we did not want to face the argument that Your Honor poses, and that is that the plan of allocation paid stockholders who were not part of the litigation class, and we wanted to avoid that argument, which is why we argued that the plan of allocation and the eligible stockholders and the should match with the litigation class.
The court.
All right, thank you.
Attorney Van Quawagen.
Nothing further from me, Your Honor, unless you have questions.
The court.
I want to know if Mr. Lafferty or his colleagues want to add anything. They did put in a response. I appreciate it. It was very helpful. I don't want to cut you all off if you have anything to add.
Attorney Lafferty.
We have nothing further to add at this point, Your Honor.
Attorney Van Quawagen.
I apologize, Your Honor, but I also have nothing to add unless Your Honor has any questions.
The court.
All right, great. Well, I appreciate everyone's presentations. I'm going to go ahead and rule on the settlement now. No one actually opposes the settlement. No one actually filed an opposition to the settlement. What TransCanada filed was a strange brief that said that TransCanada does not oppose the proposed partial settlement per se, but, nevertheless, raised an objection to the class definition. I don't think TransCanada has standing to object. It's not a party to the settlement. It's not a member of the class. It's expressly excluded from the definition. There is an exception, admittedly, where the non-settling defendant can demonstrate they will suffer some formal legal prejudice as a result of the partial settlement. I don't see any basis for any claim of prejudice. To the extent that there is some form of liability imposed on TransCanada after trial, TransCanada will have its rights under the Delaware Uniform Contribution Against Tortfeasors Act. That's what TransCanada gets. What TransCanada doesn't get is the opportunity to insert itself in an otherwise arm's-length bargain between two parties to restrict what they can agree to in terms of their releases and the class that they can propose. Now, there might be some contractual basis for that. I don't know if TransCanada had a consent right. There's been the representation made that TransCanada reviewed the settlement terms when they were being negotiated. But in terms of this motion, I don't think that TransCanada had standing to object. The parties had separately briefed the motion for class certification. The plaintiff didn't re-engage on the class definition when it moved for approval of the settlement. TransCanada filed a brief that was in every respect a surreply on the motion for class certification. I don't get it. We had this issue once in the case before. I think Mr. Yoke remembers this issue. I actually think Mr. Massengill was on the phone. I think Mr. Lesnar was on the phone because he tried to speak up on it. I addressed this specifically. I don't know why you all are having so much trouble following the rules. I don't know what I can do to try to get you to follow the rules. The court isn't used to having lawyers, particularly Delaware lawyers, have so much trouble following the rules. I thought about striking this. I thought about imposing some additional sanction along the lines of the fee that I asked Mr. Yoke to pay, and which he responsibly did pay, and I appreciate his doing that. I want to say again, I don't know what you all are doing, and I don't understand it as a matter of judgment either. The key claim in this case, or one of the key claims in this case, is that your client doesn't follow the rules. One of the key claims in this case, at least as it's shaping up, is that there was a don't ask, don't waive standstill that your client allegedly, with the help of its legal counsel, blew through. And what you all come in here and do is you keep demonstrating that same behavior. It's evidence of conduct, and there's reasons why and times when we can consider it. Intent is one, and what I've got is a party that is just repeatedly not following the rules, and I do not understand it. I tried to be clear when I put Mr. Yoke on the spot the last time around as to what I expected. I wanted to put it behind us. I wanted a clean slate. I didn't want anybody to mention again. I suspect it was embarrassing for Mr. Yoke. It wasn't pleasant for me. I have a lot of respect for Mr. Yoke. Everyone on the court does. And I thought we were going to be done with it. Yet here we are again. So I just ask you all to think about it. All right. My first task is class certification. I am not using the same definition for the litigation class that I certified. I'm going to use the definition that is actually in the settlement papers, for all the reasons I discussed in my ruling for class certification, and which were ably presented by the plaintiffs and by Mr. Lafferty in his response. That type of definition is both customary and appropriate in a settlement context because one of the sets of claims that the plaintiffs also have the ability to release are the claims of claimants under other types of law, such as the federal securities laws or common law. We know that from Matsushita case, which was a decision related to the MCA litigation in this court. So I have no problem certifying the class. I think it's clear that it doesn't have to be the same class that is used for the litigation. I see zero risk of prejudice to TransCanada. In terms of the procedural requirements, the affidavits that were required under the rules have been filed both for purposes of Rule 23, Ebele, and Rule 23E, Rule 23, AA, and Rule 23E. I have reviewed the steps that were taken to distribute notice of the settlement. The form of the notice was adequate. It was admittedly cursory. I had a discussion with my clerks, as I often do, when they look at these notices and come talk to me about them. And they say, this is really all it has to say? And I say, yes. That's really all it has to say. It adequately described the lawsuit. It adequately described the settlement consideration. It stated the location, date, and time of this settlement hearing. And it explained how the class members could obtain additional information by contacting plaintiff's counsel. The record reflects that it was adequately distributed. We have the affidavit of Eric that effort. I appreciated the disclosure of the data error and the steps that were taken to remedy it. That's the type of candor that the court is grateful for, and I commend AB Data for agreeing to pay for the updated notice. That strikes me as appropriate, and it is appreciated. In terms of the merits of the settlement, the question is whether the terms of the proposed settlement are fair and reasonable, recognizing that this court generally favors settlement of complicated litigation. I, nevertheless, have to be involved because of the fiduciary nature of the class action, which requires that the court participate to determine the extent of the settlement's fairness. The core question is whether the settlement falls within a range of reasonableness that parties could accept. Those are paraphrases of Gatz v. Ponsolt, the Philadelphia Stock Exchange case, Polk v. Good, and other decisions. In terms of the settlement here, it is a settlement that I have no problem approving. The plaintiffs asserted claims that Skaggs and Smith breached their fiduciary duties during the sale process. The plaintiffs had established a meaningful evidentiary record supporting their claims that Skaggs and Smith had breached their fiduciary duties. That evidentiary record differed in material ways from the record that had been developed in the appraisal action because of differences in how discovery in this case unfolded. That doesn't mean that the plaintiffs were going to win. It's always difficult to prove a breach of fiduciary duty, so there was certainly risk. The parties reached a settlement after negotiating at arm's length. The settlement consideration is $79 million, less the award of fees and expenses. The settlement doesn't release claims against TransCanada, and the plaintiffs will be able to continue to seek an additional monetary recovery from TransCanada. The plaintiffs have pointed out that in absolute terms, the settlement is one of the largest involving individual fiduciary defendants that have presented to this court. I've taken that into account. I've also taken into account the size of the settlement relative to the size of the transaction and the potential damages and those sorts of things. Based on my consideration of the record and what has been presented, I think that the settlement falls within the range of reasonableness, and I am happy to approve it. I would also like to express the court's appreciation to Judge Lane Phillips, who assisted in the mediation and helped get this settlement to a conclusion. The involvement of a skilled mediator like Judge Phillips is always a positive factor that gives the court comfort. So having approved the settlement, the next question is counsel's request for an award of attorney's fees. They've requested an all-in award of $18,170,000, representing 23% of the settlement, $18,170,000, representing 23% of the settlement consideration. That award is supported by Delaware law, and I will approve it. In brief, Delaware's policy is to ensure that even without a favorable adjudication, counsel will be compensated for beneficial results that they produced, provided that the claim was meritorious and had a causal connection with a conferred benefit. That's from the Allied Artists case. The Sugarland factors are the criteria that we apply. The most important is the size of the benefit. Here, we have a self-pricing benefit in the form of $79 million in cash. The court also considers the stage at which the litigation has settled. The goal there is to avoid creating an incentive, or to mitigate any incentive that the plaintiffs might have to settle early for a bird in the hand, rather than attempting to get fair value for the case. To assess that factor, the court considers the stage of the case and evaluates the type of percentage that the plaintiffs have requested. The percentage of the recovery here is right in line with at least my personal views as to what is an appropriate percentage. Those percentages are drawn from the America's Mining case from the Delaware Supreme Court. The other factors to me don't warrant a major upward or downward adjustment. The case was certainly difficult and complex enough to warrant this type of recovery. As I suggested, this has been a tough slog for the plaintiffs. There is already an appraisal decision that made findings that were, I would say, mixed in terms of their outcome. Some favored the plaintiffs, but some certainly were beneficial to the defendants. The plaintiffs faced a hurdle in terms of that, in addition to all of the other hurdles that normally arise in these types of litigation. So that factor supports the fee award. The plaintiffs litigated on a contingent basis, which is also a factor that this court considers, and the plaintiff's standing and ability supports the size of the award. I've also considered the time that the plaintiffs expended as a cross-check and the implied hourly rate. The implied hourly rate is not excessive. It's actually relatively conservative relative to some of the awards that this court has approved. So for all of these reasons, I'm approving the fee that was requested. So at this point, I usually look to see if there's any type of updated form of order that people would like to have me enter. If not, I'm happy to go down and do something through LexisNexis. What's your preference?
Attorney Weinberger.
Whatever the court's preference is. I have a copy of the final order here handing
The court.
All right, it's a sad day for the court. This is Vice Chancellor Slight's official day of retirement. As I wrote the date, that fact jumped out in my mind. He's going to be around. I don't think he's disappearing. He's been a fantastic colleague. He is a great friend. We're all going to miss him. So having written the date that I know to be his last official day in the order, I wanted to acknowledge that. I'm grateful for everyone's time today. I'm going to hand the signed order to the I appreciate everyone's time and consideration. We stand in recess.
Proceedings concluded at 12:12 p.m.